Hi, I'm Simon, the Principal Lawyer at Gippsland Community Legal Service. In this video, two of our lawyers, Simon and Taylor, will introduce you to the key aspects of evacuation orders that you need to consider as part of your planning for fire emergencies in Victoria. Gippsland Community Legal Service acknowledges the traditional custodians of the land on which this video was created and we live and work, the Gunai-Kurnai people. We pay our respects to their elders, past and present. We extend those respects to the traditional custodians of the lands on which you are viewing this video today. This is, was, and always will be Aboriginal land and was never ceded.
Before we begin, we'd like to draw your attention to some important points. Firstly, bushfire emergencies are governed by state laws, so the legal information in this video is based on Victorian law. If you live or work in a community bordering New South Wales or South Australia, you may be subject to the emergency laws of those states, which differ from Victoria. We won't be covering those interstate laws here. Secondly, although the legal powers discussed in this video apply to all types of emergencies in Victoria, the information focuses only on those powers in relation to fires. This information should not be relied upon for other emergencies, for example, flood, storm or earthquakes. Thirdly, the legal information in this video may cause distress in some people. If you experience this, stop the video. You can always come back to it later. If you need help to manage distressing feelings, contact one of these services. Finally, the law is always changing and evolving. The content in this video is current as at September 2023.
In this video, we will cover 6 key areas to explain your rights where evacuation orders are given in a fire emergency. The key areas we will cover are: to set the tone, we want to stress the importance of having a bushfire plan. So, do you have a bushfire plan? It is important to have written plans that are tailored to your individual circumstances and capabilities. Leaving decisions to the last moment may mean making decisions while you're in a heightened physiological and psychological state, meaning that your capacity to make reasonable decisions may be limited. Bushfire planning may involve having plans A through to F to cover many situations and even last resort options. The CFA, Bushfire Resilience Inc. and Red Cross websites have helpful guides, webinars and plans which may assist you in getting started. The CFA's resources are extensive. These resources will walk you through bushfire planning and help you consider questions such as: which fire danger rating is your trigger to leave? Is there anyone outside your household who you need to help or check up on? And what will you do if there is a fire in your area and you cannot leave? It is too late to start planning in an emergency. Planning and preparing before the fire season means you know what to do when a fire poses a risk to you and your property. Review your plan annually. Ensure everyone within the household understands their role and how to do it. Use practice sessions to identify any problems and amend your plan if necessary. A written and well-practiced plan will help you remember what needs to be done during a crisis. Now, Simon will take you through how to be legally prepared for a disaster.
Bushfire planning and preparation doesn't just mean planning for the fire event. It includes preparing for your recovery after the bushfire. In the immediate aftermath, people may experience trauma and exhaustion and have difficulty absorbing and communicating information and making decisions. For those impacted by a bushfire, recovery involves answering a lot of questions and producing documents that relate to proving identity, ownership of land and goods, the right to claim insurance, grants or emergency assistance, or the right to act on behalf of someone else. Planning for a better bushfire recovery includes preserving important documents in a documents kit. These may include insurance policies, property inventories, rates notices, certificates of title, mortgages, wills and powers of attorney, medicine prescriptions, passports, visas, birth certificates. You should also include any current parenting plans or court orders. The Victorian legal profession has put together a list of documents you should securely store and/or take with you when leaving. You can find this list on the Disaster Legal Help website. If you do this as part of your bushfire preparations, you will have a better recovery experience. If your documents are lost or destroyed, don't despair. They can be replaced with the help of community legal centres or other members of the Victorian legal profession. Call your local community legal centre or Disaster Legal Help Victoria to access free legal help with documents, insurance or other issues. Also, Vic Emergency website has information about accessing emergency financial assistance after a disaster. Now we come to the law relating to bushfire evacuation orders in Victoria. The powers relating to evacuation orders and the triggers for the exercise of those powers are contained in multiple statutes. Here are the main ones. In these statutes and associated regulations, the Parliament has given different government bodies and authorities the legal power to respond to disasters and emergencies. The powers are deliberately broad to allow those authorities to respond appropriately to any circumstance. The main focus in this video are the powers outlined in the Country Fire Authority Act, but we will also briefly explain those contained in the Emergency Management Acts and the Fire Rescue Victoria Act. It is important to know that the powers given to different authorities to order evacuation are triggered in a variety of circumstances. It is less important to know exactly which power an authority or person is relying on at any given time during an emergency. In a bushfire emergency, you should assume that a person giving an order has the authority to do so and comply with that order. There may be legal consequences if you don't. If you have questions about a person's authority, it is best to seek legal advice after the emergency is over. If you're in Gippsland, you can call GCLS for free advice. The objectives of the law are quite simple. They include the protection of life and property. This objective is the result of several royal commissions and inquiries into previous bushfire disasters, which urged governments and decision makers to prioritise human life above all other objectives. It is the paramount objective and is becoming more explicit in different areas of public policy and law, and particularly in planning law. Other objectives include public safety, for example, in the safe evacuation of whole towns or villages, the safety of emergency personnel such as the CFA, police, park rangers, ambulance crews, security of evacuated premises from ongoing fire risks or theft, and access to public and private resources such as water during a firefighting campaign. Next up, Taylor's going to explain the legal powers to order evacuation in a bushfire emergency.
The evacuation powers we will focus on are the State of Disaster Declaration, the Declaration of Emergency Area, removal powers, and orders to withdraw. I will now explain these powers, who has them, and how they can be enforced. The state government has the power to declare a state of disaster. The first use of this power was during the 2019-2020 Black Summer bushfires. The power was further exercised throughout the COVID-19 pandemic. The Premier has the power to make the declaration. Once declared, it comes into effect immediately and can remain in force for 1 month with the power to be extended, revoked, or varied. A state of disaster declaration enables the Minister for Emergency Services to control and restrict movement in and out of the disaster area. This means that you may not be able to leave a disaster area if you stay, which may apply for weeks or months. This declaration can require the evacuation of an area. There are, however, circumstances where you cannot be compelled to leave. This relates to pecuniary interests, which Simon will discuss shortly. These powers may also prevent you from returning to your home once you have already left. Generally, it is the responsibility of police to carry out these powers and ensure compliance. This is set out in the State Emergency Management Plan. Moving on to the Declaration of Emergency Area, as distinct from a State of Disaster Declaration. Police have the power to declare an emergency area. To make this declaration, a police officer must be a senior sergeant or above. The declaration can last for up to 48 hours and can be extended for another 48 hours by the Emergency Management Commissioner if they are satisfied that there is still a risk to public safety. In order to make this declaration, police must be of the opinion that because of the size, nature, or location of an emergency, it is necessary to exclude people from the area. The declaration provides the power to restrict or prohibit access into the emergency area, direct any person within the emergency area to immediately leave via the safest and shortest route, or authorise a person to enter or remain in the emergency area and place whatever conditions they see fit on this authorisation. Note, you cannot be forced to leave where a pecuniary interest exists. This declaration has never been used in a fire emergency. Regardless, it does not matter which power is being enforced. It matters only that the powers exist and are broad. They provide power to many authorities, and it would not be favourable to argue with police about which powers are being enforced while a bushfire emergency is unfolding. The Fire Rescue Victoria Act provides powers to fire brigades and other fire or emergency service units or those assisting under the direction of a brigade. These powers may extend very broadly to many different people or authorities. Under this power, brigades can order withdrawals from burning premises or one that is threatened by fire. You must comply immediately if you are given orders to evacuate. If you refuse, brigades have the power to forcibly remove you. This power does not authorise forcible removal where any person has a pecuniary interest in any goods or valuables whatsoever on that property. Lastly, the CFA Act provides evacuation powers to the CFA, park rangers and police. Evacuation may be ordered where there is a threat of fire, a fire burning, or if a fire has recently been extinguished. CFA officers, including volunteer members, have the power to order a person to withdraw or evacuate from the scene of a fire. Park rangers may also give orders for withdrawal where they have been directed by the CFA to do so, and in certain circumstances where the CFA is not present. Police are responsible for supporting the CFA in maintaining their authority and enforcing compliance with orders made at the scene of a fire. If you interfere with operations of the CFA and do not withdraw after being ordered to do so, you may be forcibly removed by either the CFA or police. It is important to understand that the CFA also have the power to procure water from your property and or shut off any main pipes or other water supplies to obtain greater supply and pressure of water for the purposes of extinguishing the fire. Now we have covered the powers that would likely be exercised in a bushfire disaster, Simone will cover the rights to stay and defend and access your property in a fire emergency.
In Victoria, you have the right to stay and defend your property, with or without the assistance of the CFA, if you have a pecuniary interest in the land, building or valuable goods on the property. If you have a pecuniary interest, you cannot be compelled to leave if you are already on the property. Make the decision to stay and defend early. It's not just landowners that may have a relevant pecuniary interest. Renters, share farmers, owners of goods in a shop or factory, and owners or leaseholders of a caravan in a caravan park will also have a pecuniary interest and may stay and defend. If you plan to stay and defend a property in which you have a pecuniary interest but leave the property during an emergency, you can be ordered not to return to the property. If you're on property in which you do not have a pecuniary interest, the police, CFA or park rangers can order you to leave the property. This may impact those who plan to help friends or neighbours to defend their properties. We will discuss pecuniary interests in a moment. It's important to address the situation of children and other dependent persons in the context of staying and defending. Parents have a legal responsibility for children until they're 18 years old. This includes obligations to not expose children to risk of harm and to make decisions in their best interests. Child protection laws are very clear about this. We strongly caution against allowing children and young people under the age of 18 to stay and defend the family property in a bushfire. We encourage you to plan for them to leave early, to stay with family or friends outside of the emergency area. The same obligations apply to legal guardians of a dependent adult. You should plan for them to leave early and be placed in the care of someone who is able to meet their needs. A pecuniary interest is a property right in land, goods and chattels. It's an old technical legal term for which there is no single definition or exhaustive list. Whether something is or is not a pecuniary interest is ultimately a matter of interpretation for the courts. You can also think of it as a financial interest in land, goods or chattels. Here are some examples of what may or may not be pecuniary interests. Your home or land, farm machinery and livestock are very likely to constitute pecuniary interests. Future inheritances, such as being a beneficiary of a property in a will where the will maker has not yet died, are not pecuniary interests. But what about a car, jewellery or furniture? Probably the best answer is it depends on the nature of the interest, its value and all of the circumstances. If this ever becomes an issue, consult a lawyer. The pecuniary interest evacuation model allows a person with a pecuniary interest in land or in any goods or valuables on the land or in the building to lawfully refuse an order to evacuate. This is the legislative position adopted in Victoria. All other states and territories, including New South Wales and South Australia, have a mandatory evacuation model. Those living in border communities should be aware of this when planning. The reasons why Victoria adopted this evacuation model are outlined in parliamentary debates following the 1983 Ash Wednesday bushfires. They include: remaining in the house is often the safest course of action during a bushfire, individual civil rights, the likelihood that forced evacuation will increase public confusion and panic, choke the road system and increase the difficulty of combating the disaster, and forced evacuation is administratively unworkable as it imposes a duty of care on emergency personnel who, in theory, are made liable for any injury or death occurring under their assumed control. If you're not already physically on, at or with the property in which you have a pecuniary interest, police, CFA and park rangers can direct you not to go or return to the property. If you're travelling to the property, you must obey any roadblocks or road closures, even if they prevent you from accessing your destination. The police, CFA or park rangers can prohibit you from returning to your property until the CFA assess that the roads leading to your property and the property itself do not pose a risk to your life, a risk of reigniting the fire, or a risk to the property. This may take days or even weeks. GCLS is aware that the exercise of these powers, particularly road closures, caused considerable frustration for some people in small and remote communities in the 2019-2020 bushfires. Our goal here is to inform you of the law so you can make early decisions and prepare. If your plan is to stay and defend, it's important that sufficient equipment, resources and provisions are at the property well in advance of an emergency warning so that you don't have to leave the property and risk being prevented from returning. So plan to stock up early. Let's consider a couple of scenarios. These are based on the real experiences of some members of our community in the Black Summer fires.
Alright, so here's the first scenario. It is too late to leave. The bushfire front is approaching your direction. You implement your last resort plan to stay and defend your home. You do not have sufficient provisions at your property. You travel to town to stock up on food, tools and fuel. On return, you are stopped by police who have blocked off the most direct route to your property. You believe this was the safest route. You spend 15 minutes arguing with police about returning to your property and by which route. What are the potential consequences?
Well, there are a couple of things. A police officer can order or direct you to not return to the property and to leave the area by the safest route. You can be fined for disobeying a direction to not return to the property or take a different route. The police can charge you with an offence if you do not comply with a direction. You can be arrested or forcibly removed if you refuse to comply with a direction. Consider that by arguing with the police during an emergency, you may be putting yourself and the officer at greater risk. You may also be preventing that officer from assisting in the evacuation of others. The point of planning early is to avoid this situation altogether. Let's take a closer look at some of the legal consequences.
The consequences of not complying with orders can be significant. It is a criminal offence if you do not obey directions of CFA, police or park rangers, or any authorised officer acting on their direction. Police and CFA and authorities acting on behalf of CFA can forcibly remove you. Potential penalties can include fines, arrest, or being charged on summons. If you receive a charge on summons in the mail, you should seek legal advice. It is very important to be aware of your court dates and seek an adjournment from the court early if you are unable to attend.
Here's another scenario. You decided early to stay and defend your home and the homes of your community. You cart surplus water and fuel to your neighbour 15 kilometres away. You stay to assist your neighbour to defend their home. The CFA attend the property and order you to evacuate the area. You refuse to evacuate. What are the potential consequences?
Yeah, that's a tricky situation, Simone. The CFA can order you to evacuate because you do not have a pecuniary interest. If you refuse, you may be forcibly removed, or the CFA may report you to police, which may result in a fine or charge on summons.
But would that change if you had a different asset on the property, for example, a bulldozer?
Yeah, that's an interesting one. As Simone indicated earlier, there is no single legal definition of a pecuniary interest. In this instance, it is likely that the bulldozer would be considered a pecuniary interest and your refusal to evacuate lawful.
So what if I wanted to dispute a fine? The legislation we've covered in this video doesn't provide mechanisms to dispute these powers. The powers are deliberately broad and generally can't be disputed. The objective is to ensure public safety and compliance in an emergency situation. However, this does not mean that you can't dispute the factual circumstances surrounding the specific use of a power. If you are fined or charged with an offence or arrested and you disagree with the evidence against you, you should obtain legal advice immediately. In closing, recovering from a disaster doesn't just involve dealing with the problems directly arising from a bushfire, for example, insurance or lost documents. It's a time when everyday problems which existed before a fire may also come to the foreground. Many of these problems will involve legal issues, but you may not identify them as legal problems. You can see some examples here. Community legal centres, or CLCs, are your first point of contact for free legal help in your geographic area. We can identify the legal issues and help you resolve them. There's a CLC servicing every region in Victoria. You can find your local CLC at fclc.org.au, or you can contact Disaster Legal Help Victoria. Finally, only lawyers are qualified to give legal advice in Australia. Do not accept legal advice from a non-lawyer or from Google.
Thank you for tuning in today. If you have any questions about the issues raised in this video, get in touch with us at Gippsland Community Legal Service. We can travel to communities in Gippsland interested to learn more about this topic and are happy to receive requests on other areas of law.
Thanks for taking the time to watch this video today. Gippsland Community Legal Service provides free legal services to people who live, work or study in Gippsland. Our advice service is available Monday to Friday, 9 a.m. to 5 p.m, and the help that we provide ranges from basic advice to help you navigate a legal issue to in-depth casework. We also provide assistance in some more specific areas, such as duty lawyer services for family violence intervention orders and family law matters, outreach advice services across Gippsland, victims of crime legal services, and disaster preparedness and recovery. Our disaster preparedness and recovery work began in Outer Gippsland in 2020 after the Black Summer bushfires. As part of that work, we've provided free advice, assistance and representation to people recovering from the disaster across a wide range of legal areas. We've also developed resources and presentations to help educate our communities about the legal areas relevant to disaster preparedness and recovery, and our lawyers provide regular outreach services to communities across East Gippsland.